co-sharers of the stage, and ladies and gentlemen, you are told about what Shakespeare thinks about lawyers. He did say that first thing we do is let's kill all the lawyers. But he was a poet. A president of the United States made a public statement that for all the ills that ail the Commonwealth, it is the lawyers who are responsible. And let me tell you a joke against my own profession. The pharmaceutical laboratories in the United States have now decided that they are going to use in their laboratories lawyers instead of rats. I thought that perhaps lawyers had some contribution to make to the growth of science. But then the laboratories proceeded to give 3 reasons for their decision. Reason number 1, that lawyers are more numerous than rats. Well, that was not bad. They may be. The second, that it's difficult to fall in love with lawyers, as occasionally we do fall in love with our rats. The third was more humiliating, that there are certain things which lawyers do which even rats will not do. But ladies and gentlemen, I believe that just as God has told us that man can never do without woman, you cannot also do without lawyers. And no wonder that out of 6 people here, at least 3 or 4 should be considered as lawyers. So that's my defense. But my further defense is that every bad section of society can be neutralized by good rulers and good politicians. Unfortunately, our politicians are worse than our lawyers. I don't know whether you have heard the latest joke about politicians. Somebody said that if one politician falls into a river and dies, it will be a simple case of pollution. But if all politicians fell into the river and died, that will be the solution. I plead guilty to the charge of belonging to both these professions, ladies and gentlemen. That is why I don't advertise these, but unfortunately these are advertised, and the only profession of which I am very proud, and which is my third profession, and my third profession is of a law teacher. I have practiced law for 70 years, but I have taught law for 71 years. So that I am proud of, and I hope more and more law teachers will find a place on this kind of a stage and come and talk to you. Now I must confess that when I received this invitation, and my office put it to me day before, I looked at it and I said, I don't think I have very great wisdom to impart on this topic. But then I saw the distinguished list of speakers who were supposed to speak before me, including Mr. Kajju, the most talkative chairman of the Press Council of India, who has always great wisdom to impart on every subject of the world. So I thought that he is there, so he will educate me by the time my turn comes, and I will be able to make some contribution thereafter. But anyway, I am very glad that Mr. Bajaj and our very distinguished judge, they have already educated me about the problems that you are facing, or which society is facing. Now, first of all, ladies and gentlemen, let me talk of the so-called privacy. It is wrong to think that privacy is not described as a law, as a right in the Constitution. Privacy is a part of human liberty. I am entitled to keep my affairs as private as I can, subject, of course, to some overwhelming and imperative powers who can override my free will, but I am entitled to maintain as much secrecy as I can, which is a part of life and liberty, and Article 21 guarantee under the Indian Constitution. You have perfect liberty unless somebody else is armed with some legal right to interfere with your liberty of keeping your affairs secret. So secrecy and privacy do not require any specific mention in any article. It is there in the right of what is called life as well as liberty. Now, this article has a bit of a history. This article, when debated in the Constituent Assembly of India, many people brought in the notion of due process of law with which the American Constitution is very familiar. Our Constituent Assembly expressly debated the doctrine of due process of law and rejected it. Therefore, they said, unlike the American Constitution, does not use the expression due process of law, but it uses the expression life and liberty cannot be taken away except in accordance with procedure established by law. And by a majority judgment, and the only dissenting judge was the great prophetic judge, Mr. Justice Fazil Ali in those days. I'm not talking of the second Fazil Ali. The first Fazil Ali, who sat in the first Supreme Court of India, he is the person who delivered a dissenting judgment and almost said that our article also means the same thing as due process of law recognized by the American Constitution. But ladies and gentlemen, the other judges overruled him, and that remained law until that old law was superseded in the Maneka Gandhi case by a larger bench of about 7 judges. We brought in by judicial legislation the doctrine of due process of law in the Indian Constitution, and due process of law means that it must not merely be procedure established by law, but it must be a law which in its substantive content as well as procedural content must be a very reasonable law, and whenever we talk of a reasonable law, it means reasonable to the satisfaction of the judiciary and not the executive. That is the great change now in the constitutional law after so many years. Maneka Gandhi's case, I believe, was decided soon after the emergency in 1980 or something. And today, that is the law, that your right to privacy cannot be taken away except in accordance with a law which is procedurally as well as substantively reasonable to the satisfaction of the judiciary. And ladies and gentlemen, that compares very well with the corresponding history of legislation and judicial interpretation of that legislation and subsequent legislation that has been passed in the United States. The United States also originally did not have any right to privacy in the Constitution, but the 4th Amendment of the American Constitution brought in what is called the doctrine of privacy. All that it says is that every citizen has a complete right to be protected against unreasonable searches and seizures. Now, when you are trying to pry into the privacy of a particular person and get information about his private life, you are really searching for something. And the American 4th Amendment said that there shall be complete protection against unreasonable searches and seizures. And this rule of privacy was canvassed by eminent lawyers appearing in the Supreme Court, first time in the year 1928, but the Supreme Court took a very conservative view of the law. They went by the textual interpretation of the word search and seizure. They said that search and seizure can only apply to material property and it can't apply possibly to knowledge. After all, you can't seize knowledge, you can't search knowledge. I don't know why you can't search knowledge. You can certainly search knowledge, though you may not be able to seize it in that sense. The seizure concept, textually adopted by the Supreme Court, rejected any notion of privacy under the American Constitution. And from 1928 onwards, able lawyers, very eminent lawyers, and some eminent judges, but always in a minority, by 5 to 4, every time the doctrine of privacy was totally overruled by the legislation, by the Supreme Court of the United States. Ultimately, in the 70s, the Supreme Court of the United States became a little more friendly to the privacy of individuals and at least said one thing, that you cannot take away somebody's privacy unless and until there is a probable cause established to the satisfaction of the judiciary and not the executive, that it is necessary to interfere with privacy of an individual or an individual citizen. Now this is the latest position of the law today. Then if you read the authorities under the American Constitution, there are plenty of authorities in the year 1960, 1970, 1971, 72, a large number of authorities, probably the last one is of 1975 or so. Today, in America also, the law is that nobody's privacy can be interfered with except by a statutory provision, and that statutory provision must satisfy two things. First, that there must be a probable cause established for that invasion of privacy, and that probable cause must be established to the satisfaction of a judicial authority and not an executive officer. So ladies and gentlemen, today in India, it is unfortunate that though privacy is protected by a constitutional article of 21, because the Fourth Amendment right has been denied by the American judges, they base it on legislation of Parliament, legislation of the Congress now, as we don't have to. We rely on Article 21 of the Constitution, and all fundamental rights are subject to reasonable restrictions, but considered reasonable by the judges of the country. So ladies and gentlemen, we have two laws at least which interfere with privacy. But I think most of you are concerned with this two kinds of interference with privacy, the wiretapping, and the other is, of course, what you call putting bugs into places, and what you call secret informants. So wiretapping and you call it electronic surveillance in the wider sense, that covers all kinds of interference with privacy. But the defect of these two pieces of legislation in India is, and that's the big problem, and that is what politicians must take care of. Politicians must take care of by saying that these statutes cannot be invoked by the government or by anybody else except on sanction of an initial judicial authority, and the judicial authority must show probable cause why it is being done. Now the probable cause, they say, is usually security, public order, so on and so forth. Now nobody can deny that the government has the right to collect information for the purpose of safeguarding its security of the nation. Nobody can say that for maintaining public order, preventing insurrections and riots and so on, that you can look for information which helps you to prepare in advance to prevent these kind of dangers happening to society. Nobody can say that. But the defect is that it is left to an executive officer to decide. An executive officer who can be an employee of the state government or the central government, or a specially empowered officer by either of the two governments. Now this is bad, and judicial satisfaction of some judicially trained person must be a condition precedent, and it is the judicial mind which must first sanction the invasion of privacy. Then I don't think that there is any problem which society will face at all. Then it is subject to judicial review. You can walk up to the highest court in the country and challenge the kind of surveillance to which you are objecting, and I think you can't have a more perfect system than that. Every system ultimately is imperfect, and perfect systems are, of course, God's. Forget it. Now, ladies and gentlemen, let us come to the other side of the picture, the government. Now, first of all, democracy, of which we are very proud. Ladies and gentlemen, be sure that democracy without education is hypocrisy without limitation. Whose education? The education of the governed. not the education of the governors. Education of the governors is important from another point of view, but it is the master of the country, the real political sovereign of the country, who must be informed about how his elected representatives are the elected servants of the people conducting their affairs. Take any ordinary business. In an ordinary business, if you have a wealthy business going on, and the proprietor is an ignoramus, but his gumasta, his manager, other person running the business is a very clever man, be sure that one day that business will end into insolvency. That is precisely what is happening to this country, ladies and gentlemen. We have got clever rulers, but the ruled are without information and without knowledge, and they are all the time being subjected to exploitation of which they are not aware. And they are not aware of the fact that India is not a poor country as the politicians pretend. Ladies and gentlemen, it is my firm belief that India is a rich country which has been made poor, made to look poor by the persistent acts of grand larceny practiced by the dacoits who have come in possession of our political power. And this is not a matter of merely getting onto a political platform. I am not speaking at Ramlila Maidan, but ladies and gentlemen, I am talking of what I told the Supreme Court of India. I went to the Supreme Court of India and said that $1,500 billion of Indian wealth have been stolen by our dacoits. What did the French do, ladies and gentlemen? Wealth was stolen from all over the world and stashed in these tax havens. It is ultimately, I think the Germans started it first, the French came a little later. The Germans paid $475 million by way of bribe to an employee of the bank, and that employee gave them the complete reels of the customers whose monies were lying in their bank. And ladies and gentlemen, I am ashamed to say that this wind of democracy and human rights and some kind of a revulsion against this kind of larceny and hiding stolen property from all countries began to affect the conscience of even the Swiss citizens. An illustrious Swiss magazine, ladies and gentlemen, in 1991 established with evidence and gave the names of 14 international thugs drawn from all over the world with their name, their photograph, their account number, and the money standing to the credit of the dacoit in the account. I regret to say that amongst the 14, number 12 was a prime minister of this country. What has been done? Nothing has been done. Ladies and gentlemen, when I spoke about it in Parliament, the debate just broke up. Parliament went into total chaos and disorder, and the very, very cooperative chairman of the Rajya Sabha quietly adjourned the House, and the debate has never taken place since. Ladies and gentlemen, we knocked the doors of the Supreme Court. The Supreme Court said in a judgment that no effort has been made to secure this money. Every time some kind of an excuse is being made why no investigation is being done, you have no machinery of investigation of this kind. And the Supreme Court made 2 orders. After 1 year's full hearing, the Supreme Court made an order in a petition in which I gave up my gown and my bands and collar and approached the Supreme Court as a petitioner along with 4 or 5 other persons, and the Supreme Court made 2 orders. That we are not satisfied with the investigation. We are appointing a special investigation team headed by 2 retired Supreme Court judges. Please forthwith appoint this. Second, disclose the names which you have got from the Germans and the French and others to Mr. Jethmalani and his co-petitioners in the Supreme Court. Ladies and gentlemen, 2 years have gone by since the judgment was passed. That judgment has not been complied with. There are no lawyers to make a complaint. There are no politicians to make a complaint. And today, ladies and gentlemen, all the time, just because an election is on, now people are being told that we are going to give you some morsels of food. We are going to distribute free food to you so that you don't talk about your stolen wealth. So ladies and gentlemen, the citizens of this country have the right to know how the masters are working. And this creates a fundamental right in the citizens of India to know everything about governmental operations. Who found out this right? Not lawyers, not politicians, but again credit goes to an illustrious judge of the Supreme Court, Mr. Justice Mathur, who in a 1975 judgment ruled that the right of transparency of governmental operations is a right of every citizen in a democracy, and that right was spelled out from the freedom of speech right under 19(1)(a), that if you have the freedom of speech, you have the freedom to attack your government and criticize your employees. The government is ultimately the paid servants of the people, and so are the elected representatives of the people. They are supposed to yield all information to the real rulers of the country, and therefore the right in a democracy of the citizen to know what the government is doing arises out of Article 19(1)(a) of the Constitution. And now if there is a fundamental right under Article 19(1)(a) of the Constitution, ladies and gentlemen, what happens? It can only be subjected to reasonable restrictions under the Article 19(2), and it can be put under restrictions, which restrictions relate to particular topics like defamation, libel, contempt of court, these topics. And second, the restriction must also be reasonable to the satisfaction of the judges. So again, the judiciary has got to interfere in every attempt to hide things from the people of this country. A man has the right to go and tell the Supreme Court that I want to know this operation of the government, I want all information, and he is entitled unless there is a complete restriction under the law, and that law is a reasonable law, and the judiciary is able to pronounce it as reasonable. When I became the Minister of Urban Development, ladies and gentlemen, I had read Mathur's judgment. I made a first administrative order that anybody who pays 10 rupees can come and inspect any file in my ministry. And I set a cat amongst the pigeons. Oh, the Prime Minister's special secretary, Mr. Mishra used to be one secretary in those days, he called and wrote me a letter that we are all aghast. What have you done that you have opened up the whole government? I said, listen, I can't wait to obey the constitutional rights of my citizens. I am their elected representative. My Prime Minister has not made me a representative of the people of this country. He may have given me this job here as a minister. But I believe that I owe a duty to the people of this country. Then came the second letter. The second letter was that we are considering the Freedom of Information Bill and we are going to soon pass this legislation. You wait till that legislation is passed. I said, no. The right which the Freedom of Information Act will create is only a procedural right. How do you go about, who do you approach in a particular department, whether you have a right of appeal against their refusal and so on. They are only going to lay down procedure, but the substantive right to know is created by Mr. Justice Mathur under a constitutional judgment, a judgment arising out of Article 21(a), and I can't disrespect the people's fundamental right. I am going to disclose my files, ladies and gentlemen, to any citizen who pays 10 rupees. But ladies and gentlemen, that can cost you a ministry. It does. It often does, ladies and gentlemen. And so, but the trouble is that there are people who don't care. If they don't care, the people are safe, ladies and gentlemen. And today, the Freedom of Information Bill, which became Act, according to me, some of its clauses are unreasonable restrictions on the freedom of people's right to know. But that's all right. At least there is a workable law now, which under the guidance of the Supreme Court and proper interpretation of the Supreme Court is receiving a good bit of support and appreciation. And today, the government is very, very, very badly exposed, And that is why today, ladies and gentlemen, the politicians have reached a state of social unacceptability worse than that of the lawyers. So, ladies and gentlemen, I don't believe that you have really any more serious problems. The problems that arise are the problems of those who are subject to these constitutional rights of the citizen, and you are not supposed to be worried about them. Let them worry themselves to death, and please try and expose them by any kind of method that you have. If you find that you want to resort to some illegal wiretapping, please do it if you want to discover some government's corruption, and I am there to defend you in a court of law. And thank you.
As expected, Mr. Jethmalani has really activated and brought to life the entire audience. And of course, thank you for your very free and frank and also very educative talk. Now, would you like to ask any questions? And then please also tell whom do you want to address it to, Mr. Jethmalani, Mr. Mathur. Yes, sir. Kindly introduce yourself also, sir, if you don't mind.
Yeah, I'm Ravi Prasad. Yeah, I'm Ravi Prasad, a telecom consultant. Well, for the entire panel. First of all, for the last 3 years, every single international phone call in and out of India is being recorded by the intelligence agencies. Every single email is being recorded. Now, what is happening is that under the central monitoring system, which will soon come into play, 100% of the communications of 100% of the residents of India are going to be monitored and recorded for all time to come. Now, this is something that none of the 4 legislations that govern, the regulations that govern electronic surveillance in India, which is Section 69 of the Information Technology.
First of all, you should be happy that we have adopted another rule in India. That rule is that illegally obtained evidence is admissible in a court, unlike the Americans. So, by whatever method you acquire information, ultimately your judicial remedy will not suffer, because you can use that evidence in a court of law. Whatever other consequences may follow about your illegal tapping and so on and so forth, but be sure that nobody is going to punish you if you have served a good social objective or even a good political objective by your small illegal action. Now, there is some difficulty about the interpretation of those rules which you mentioned and all that, but those are absolutely minor difficulties. You have got, if you want to explore any aspect of governmental activity, please think that you are a sovereign citizen and nobody is going to punish you for making that discovery by whatever method.
Yes, sir. Can you introduce yourself?
Yes, I'm Anand Bose. I'm an advocate of the Supreme Court of India and an advisor to the House of Tata. Suman, I would seek your indulgence to make brief remarks.
Listen, I'm not the only one under cross-examination.
No, one small question and very, very brief remarks. Suman, when I had the privilege of meeting my very good friend and well-wisher Lord Denning for the last time, he expressed great satisfaction at the fact that the Indian Supreme Court had followed his thinking on the right to privacy, and of course in a very lighter vein showed me a small cutting from the British press which said, what if Lord Denning were caught in a call girl's boudoir? I'm happy that my Lord Justice Mathur had referred to Kharak Singh's case that was followed subsequently by the Supreme Court in Govind versus State of Madhya Pradesh. But the landmark decision which followed Lord Denning's case was the famous case of Rajgopal versus State of Tamil Nadu, which really brought in the concept of the right to privacy being an implied right under Article 21, the right to be left alone, and which actually laid down the law that it is a part of our fundamental right, but had to be implied from Article 21 of the Constitution. And I now come to my question, staying away from the decisions. In the Nida Radia case, I think in February this year, a bench of the Supreme Court comprising my Lord Justice Singhvi and Mukhopadhyay had said all personal conversation, I think there were over 5,000 conversations, which had to be destroyed. Now this is where I would like the panel to come in. Where do we draw a line between what is personal conversation and what is, there could be, say, a communication between the chairman of a company and a subordinate. Now is that personal, is that official, is that to be destroyed, not to be destroyed? And does the right to privacy only come in where your personal conversations are concerned, or is the right to privacy an all-pervasive right which encompasses the fundamental right to life and liberty? Thank you.
But I believe that right of privacy in that sense, and the right to seek information about governmental operations, except of course under some valid clauses of the Freedom of Information Act. Otherwise, today your privacy is wholly protected except in so far as successfully limited by a valid statutory provision. And according to me, there are no valid statutory provisions in existence today, because both these statutes which exist today do not comply with what I believe are reasonable requirements, the judicial mind application and the condition precedent of a probable cause being found initially by a judicial authority.
I'll just add one.
Yeah.
Sir.
Just one small addition here. I was just, there's a very clear demarcation actually between private and what may be intercepted by the government, at least in the Nira, Radia and Tata's case. No, definitely, but the question really is that anything which is public to the extent of even if it is between employer and employee, if it relates to a criminal transaction or leading towards that direction, it is something which is possible to be intercepted and which could be made available. As far as private conversation is concerned, that would really be in a totally different link, irrespective of holds business or non-business relations.
Sir, myself.
The litigation about Radia's tape was a little awkward, because now more people know about the contents of that document which is being suppressed from the people of India than people otherwise would have known. I mean, nobody would have known. Really, some people with a morbid taste might have. But now everybody knows in the country what the hidden text of which was thought to be suppressed.
And so it's all available on YouTube. You just have to search, you'll find it. Yes.
Sir, myself Narang. Sir, they seem to join hand and may pass an act in Parliament. No, this cannot be disclosed. Now, you know what it means, because that is the whole, how this black money going around, corruption influences, that's the key to it. So how can you help us in the system?
Look, political party doing harm to the nation, he must first forthwith completely renounce his relationship with that political party. Second, there are no perfect political parties as there are no perfect human beings. I believe that the kind of argument which people raise, no, why do we worry about this opposition? The opposition is as bad. No. You must decide who is worse.